Oyez, oyez, oyez. The Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Thank you, Madam Clerk, and welcome everyone to the call of the Tennessee Court of Criminal Appeals docket in Jackson, Tennessee for the month of November. We'll be holding oral arguments today and tomorrow. Each side is limited to 20 minutes unless we have given permission otherwise. And if you wish to reserve any time for rebuttal, please do so upon being introduced yourself to the court. We'd like to thank all the folks behind the scenes that help us make this possible. The staff at Jim Hivner's office, our staffs, and of course the staff at the AOC with Nick Morgan and others. Sometimes they have to work late in the night to get things operational. We just come and sit down and it works. Thank goodness we have wonderful people that do that. We want to thank the attorneys for their extra efforts that they've given to allow us to do this over the past year. We're looking forward to going back to court and in person in January. We hope that we can meet that goal and look forward to doing that. But last year and even the year before that has been trying on everyone, but we appreciate so much everyone's help in doing that. And with that, we'll get ready here in just a minute. But the most wonderful task I have to this morning is always introducing the panel that I serve with today, and you've got the entire state represented here. On your right, my left from Franklin, Tennessee, is Tim Easter. On your left and my right-hand person from Sevierville, Tennessee, Judge Norma McGee Ogle. And I'm from West Tennessee, John Everett Williams, up around Huntington, Tennessee. So with that, I think that's all we need to cover introductory wise. Madam Clerk, would you please call the first case?
Yes, sir. State of Tennessee versus Seddrick Curry.
May I begin, Your Honor?
Yes, please.
Okay. May it please the court, Judge Williams, Judge Ogle, Judge Easter. My name is Anna Smith, and I am here today on behalf of the appellant, Seddrick Curry. At this time, I would like to reserve 5 minutes of my time for rebuttal.
Yes, ma'am, and I'll help you keep up with that. Thank you.
Thank you, Judge. This case arises out of a denial of post-conviction relief in the Shelby County Criminal Court. Appellant is requesting this court to find in his favor and reverse the ruling of the criminal court for 3 reasons. First, trial counsel's performance was deficient because their decision to advise appellant to plead guilty was based on a misunderstanding of the law related to sentencing. Second, trial counsel's performance was deficient because he allowed appellant to plead guilty to a crime without a factual basis for that plea. And finally, trial counsel's deficient actions resulted in prejudice to appellant's case. Now, at the crux of every issue involving a claim of ineffective assistance of counsel is this balance between the avoidance of second-guessing strategic decision-making of attorneys, while also making sure that those attorneys are acting reasonably and within the best interests of their clients. Now, there's no question that in almost every case where there is an instance of an alleged deficient act, there is another lawyer claiming that that act was a product of strategy. This court and the courts whose holdings to which this court is beholden have regularly denied claims of ineffective assistance of counsel because of a belief that lawyers should have the right to offer guidance, raise objections, call witnesses, prepare arguments, all without the potential of overturning a case simply because another lawyer comes along and says that they would have done things differently. Appellant is not naive to the reality that this case, particularly given that it involves a guilty plea, invites these same kinds of responses. This case, however, presents an opportunity to clarify the distinction between strategy rooted in complex decision-making and strategy rooted in a misunderstanding of the facts and laws in a case. To review some of the background of this case, Mr. Curry was sentenced on 4 charges under 2 separate indictments. Both indictments involved a charge of aggravated burglary and theft of property. In one of the indictments, the theft of property was over 1,000, and in the other, the theft of property was over 10,000, but below 60,000. Mr. Curry pled guilty to both charges for each indictment on an open plea. And this is significant because Mr. Curry's trial counsel was aware that the state would be objecting to his request for anything other than the maximum time that would be offered for these charges. Part of the reason that this was the decision of Mr. Curry was a belief, and what appellant will now argue was a mistaken belief, that the only way that he could request alternative sentencing as an option would be to plead to all of the charges, whether he agreed that he had committed those crimes or not. For each indictment, the court did in fact sentence Mr. Curry to serve each of the charges within an indictment concurrently, but the two indictments together, he was sentenced to serve consecutively. It is also appellant's position that trial counsel was unaware of the fact that these charges on the two separate indictments would require mandatory consecutive sentencing. And this is significant because Mr. Curry allegedly committed the second offenses under the second indictment while he was out on bail for the first charges. And as your honors are aware, as a result of committing an alleged act while out on bail, the court has the mandatory sentencing of consecutive sentences. So if there had been enough diligent investigation, it should have been obvious and apparent to trial counsel that mandatory consecutive sentencing was going to be necessary. Both pleas required Mr. Curry to plead guilty to the theft of property. As I mentioned previously, the theft of property in one of the cases was over 1,000, and that did match the facts that had been provided by the state, both during discovery, but even in their seeking of the indictments. But the second case involved theft over $10,000. Appellees stated in their brief that this argument about the $10,000 was not raised in the issues presented for review. Appellant disagrees with that, given that we raised the issue that trial counsel had allowed Mr. Curry to plead guilty to a claim without there being a factual basis. And that, of course, was a significant portion of the argument that we made both in the hearing and certainly in our brief.
But did he not stipulate that there was a factual basis?
He did, Your Honor. His counsel stipulated that there was a factual basis, and part of our contention, and I think even the trial court, after hearing the full petition hearing, determined that it was in fact deficient for his counsel to stipulate to that factual basis, given the information that had been provided. There was no allegation by the victim, by the state, that more than, I think, $4,600 of items was stolen, and that included roughly $2,000 in cash. And while I think during the hearing, the point of view that was offered by both the state and Mr. Gotten acting in sort of hindsight was that, well, the state can offer more evidence to prove up their case even more at trial. However, given that the amount was less than half of what the state was alleging and included an inventory of items that had been retrieved from the victim, it, I think, is unreasonable for the lawyer to assume that that factual basis would be met. And so for the lawyer to then stipulate to that factual basis, especially knowing that Mr. Curry was adamantly denying and had raised that issue and raised a discomfort with the amount, I think is just another product of the lawyer operating basically with a mind towards the path of least resistance. So during the post-conviction hearing, the lawyer had articulated, and Mr. Curry had articulated, that the rationale behind not challenging the $10,000 amount was that the state would be angry at the challenging of this, and then he might not get the alternative sentencing. But the reality is there was no negotiation that was on the table. There was no promise by the state that required a plea as charged in order to recommend a particular sentence. In fact, they knew that the state was going to adamantly oppose the sentence that they were requesting. They were essentially asking for the mercy of the court. And so despite, I think, multiple claims on behalf of the trial counsel that he had negotiated and negotiated and negotiated, there is no evidence to suggest that this sort of factual inaccuracy was a part of that negotiation, because there was no attempt from any of the record that we've seen or we have before the court that counsel actually ever tried to get the state to reduce that charge. And frankly, it would have made sense for the state to reduce that charge from 10,000, especially given that the proof that they had. I don't think the state is in the business of trying to overcharge individuals with higher amounts. I think it was probably the product of an oversight, having not looked fully through the inventory prior to discovery and after the indictment. And especially given that any charge for theft was going to be less than the charge for the aggravated burglary, the state really didn't have an incentive to fight against that. If anything, I think that speaks to the lawyers' failure to even do a minimum level of anything beyond just sort of moving through the case as quickly as possible. Especially given that Mr. Curry had raised this with him. And certainly, and I think as Appelli points out in their brief, this is a case that is going to be reviewed de novo, but with a presumption that the trial court's evaluations of things like credibility should be given deference unless the evidence in its totality preponderates against that presumption. And it's our position that the trial counsel did not really have any justifications or clear answers for these kinds of decisions, other than his belief that it was the only way to get this alternative sentencing.
What was the other way?
I'm sorry, Your Honor?
You mentioned earlier that it was not the only way. What was the other way?
The other way would be to go to trial. There is nothing that prevents, and I understand, Your Honor is laughing. I understand. I completely recognize the fact that, of course, a judge may not grant alternative sentencing to somebody who goes to trial. I am not naive, again, to the fact that that is an uphill battle. But trial courts also, I think, could have the exact same reaction that Your Honor just expressed, with the idea that somebody with a 30-year criminal history and facing 30 years in prison would ever get Jericho. I think that is just as shocking of an assumption as it would be to assume that a trial court would offer alternative sentencing, which is why our burden in this case was just to establish that he would not have pled guilty, not that he would have necessarily seen a different sentence, or what would have necessarily happened at trial. The burden on our part, it was to show that he would not have pled guilty. And Mr. Curry had stated over and over again, and in fact, Mr. Gotten had not really disputed that Mr. Curry pled guilty because he believed that he had to do so in order to get Jericho. Despite the fact that it's at least technically possible that he doesn't have to do that. He could get a final judgment through other mechanisms. And if this was somebody who had committed their first offense and had, as Mr. Curry had been diagnosed with a mental illness, certainly it would be understandable for a lawyer to say, throw yourself at the mercy of the court and get the best response that you can. But in this case, there was such a small, slim likelihood that Jericho would ever be offered. The person, Mr. Robilio, who testified at the sentencing, had even admitted himself he was unaware of any cases in a 30-year history of somebody getting Jericho in this situation. Mr. Gotten admitted in 19 years of practice, he had never seen anybody facing these charges with Mr. Curry's criminal history getting this kind of a result. And it's for that reason that we believe he was improperly advised, simply because he was not gaining anything really substantially of value by agreeing to plead guilty, and did have some reasonable factual disputes in order to try to sustain a win at trial, where the state has a burden that is a very high burden. And given that there was an exonerating affidavit, given that there was a factual dispute between the proof that was offered by the inventory of items and the allegations that the state had made in the indictment, while those might
Smith.
not have been success, I'm sorry.
Before you run out of time,
Sure.
I'm interested in hearing what you have to say about the state's claim that a panel of this court has already determined that your client did not receive ineffective assistance of counsel, and it appears to me the way your petition is set up, all of your claims hang on that claim that Mr. Curry received ineffective assistance of counsel, and looks like 3 different ways is the way it's set up. But I am interested in your response to the state's claim, and there is an opinion out of this court that clearly says your client did not receive ineffective assistance of counsel that dealt with his petition to withdraw his guilty plea. I'm interested to hear your response to that.
Yes, Your Honor. I think that that certainly is a challenge for appellant. I think that that is probably of the issues that were raised by appellee, the one that is the most difficult. I would suggest that given the framing of the argument previously and looking at the claim of ineffective assistance of counsel through the lens of whether the plea was voluntary and knowingly given is different than evaluating solely on the basis of the sort of totality of the Strickland test, which was, I think, much more of the focus of the second hearing. And I recognize that the case law that Your Honor is referencing and that appellee referenced talks specifically about the issues that are raised and the fact that raising new factual issues is not enough to necessarily overcome that issue. However, in this instance, because that I think the arguments there were more evaluated under the lens of what is a voluntary plea rather than just strictly under the analysis of Strickland versus Washington and the ineffective assistance claim, it would be our position that the court should reconsider this issue under just solely this purview. And at this time, Your Honors, that would conclude my argument at this point in time, and I'll reserve further arguments for rebuttal.
You have your 5 minutes. Yes, ma'am.
Thank you.
General, good morning.
Morning. May it please the court, Catherine Decker representing the state of Tennessee. Absolutely, this court has previously determined on direct appeal that the petitioner did not receive ineffective assistance of trial counsel. And for that reason alone, this court should affirm the post-conviction court's denial of this claim. Under the Post-Conviction Procedure Act, a claim is previously determined if a court of competent jurisdiction has ruled on the merits after a full and fair hearing. And that's exactly what happened in this case. After he pleaded guilty, the petitioner filed a motion to withdraw his guilty pleas, and he alleged essentially the same exact ineffective assistance of counsel factual underpinnings and claims that he alleges in this post-conviction petition. He had a full hearing, and in fact, the transcript of that hearing is part of the of this appellate record because it was introduced at the PC hearing. He presented testimony from Mr. Gotten. He testified, and he presented testimony from Mr. Abilio, the director of the Jericho program. He fleshed out the exact same issues that he's raising again in this context. He argued that Mr. Gotten did not properly advise him prior to his pleas, and it's exactly what he's arguing now on the same exact factual grounds. When he appealed the denial of his motion, this court specifically found that he did not receive ineffective assistance of trial counsel, and that completely disposes of this claim. However, we would like to continue with the merits. The post-conviction court properly denied the petitioner relief on all 3 of his claims. And primarily because the post-conviction court has made credibility findings that are contrary to the petitioner's testimony and also contrary to counsel's representations today. First, concerning the petitioner's claim that his trial counsel was ineffective for advising him that the guilty plea was necessary to be sentenced to community corrections and to be placed in the Jericho program. Mr. Gotten specifically testified that he did not tell the petitioner that he had to plead guilty in order to receive the Jericho, to be sentenced to the Jericho program. In fact, Mr. Gotten specifically testified that he told the petitioner he could be sentenced to the Jericho program if he proceeded to trial. So that's completely contrary to what defense counsel has represented here. The post-conviction court specifically found Mr. Gotten to be a credible witness. And so this court defers to the post-conviction court's credibility findings, and that disposes of the first claim of ineffective assistance of trial counsel. And also, as a side note, the post-conviction court found that petitioner was not a credible witness. And so petitioner's contrary testimony that he did not know he could be sentenced to Jericho if he went to trial, and that he was told that he had to plead guilty, the PC court has found that to be not credible. And again, this court defers to that credibility finding. So concerning the second claim of ineffective assistance of trial counsel, that Mr. Gotten did not adequately advise the petitioner about his chances of being sentenced to the Jericho program. The petitioner himself testified that he was told that he had a good chance to get it, and that the chances, he talked repeatedly about, he said, Mr. Gotten told him he had, quote, a real close chance, a real close chance. It was a real close decision, could probably get it. But the petitioner himself did not testify that Mr. Gotten told him he was guaranteed to be admitted into the Jericho program. Mr. Gotten testified that he researched not only the judge's past decisions and knew that he was very interested and concerned with the mentally ill. So he knew that this particular judge, if any judge would sentence him to the Jericho program, with this particular judge's history, he might be likely to do that. Mr. Gotten consulted with the director of the Jericho program, and it was told it was possible that the petitioner could be sentenced to the program. They might not have seen it in this particular, with a petitioner with this particular history, but it was still possible. And Mr. Gotten specifically testified that there was absolutely no guarantee that he would get it. So again, the post-conviction court has made credibility findings that that Mr. Gotten's testimony is credible, the petitioner's testimony, any testimony contrary to that is not credible, and implicitly has accredited petitioner's own testimony that he was told there was no, that he would have a real close chance, but just a real close chance of being sentenced to the Jericho program. In overarching finding of the post-conviction court as well is that Mr. Gotten and the petitioner made a strategic decision to plead open to the court and to petition the court for community corrections and a sentence to the Jericho program. And this court properly defers to a strategic decision made by counsel. I want to briefly address Ms. Counsel's statement that trial counsel was unaware that, or misadvised the petitioner that he, or was unaware that the petitioner would be subject to mandatory consecutive sentences. But in fact, there's no, in fact, what the counsel testified to was he was aware that a defendant who commits an offense while on bond is subject to mandatory consecutive sentencing. And counsel also testified that he spoke with the petitioner about that. And that's on pages 85 and 86 of volume 3 of the record. So there's no, it's just completely contrary to what counsel has represented here. And finally, the third claim that counsel was ineffective for allowing the petitioner to plead guilty to a charge of theft of property valued at over $10,000 without sufficient factual basis for the amount. The PC court has found the counsel deficient, but properly found that the petitioner was not prejudiced because he failed to prove that, but for deficiency, he would have insisted on going to trial. And first, and this is actually builds on what defense counsel has stated here, the petitioner was well aware that there was an issue with the valuation before he pled guilty. He was well aware of that. He testified that he brought it to counsel's attention twice. So still being aware of that, he pled guilty. So it can't be that he wouldn't have pled guilty had he been aware of that issue, because he did in fact plead guilty. But
Well,
also,
didn't he say though, he was aware of it, but he thought he had to plead to the indictment, the specific indictment.
he might have thought that, but he nevertheless went ahead and pled guilty. But more than that, he pled guilty to the act of this theft, thinking that the valuation, it was a higher valuation. It makes no sense at all that he would not have pled guilty to this act of theft if he thought it was it had a lesser valuation. He was willing to plead guilty to the higher valuation, even knowing there was an issue. So certainly he would have pled guilty to that act of theft if the valuation had been less. But also, more than that, Mr. Gotten testified that, so there are two charges, and the one that we're talking about now is the first one, a burglary and that theft. Second, there's a second charge altogether with another burglary, another theft. It was this first charge involving this theft that Mr. Gotten testified that from the outset, the petitioner wanted to plead guilty. He wanted to plead guilty to this burglary and this theft from the outset. He initially did not want to plead guilty to the second charge of burglary and theft because of what he at one time thought might be an exonerating affidavit concerning the other charge. But as to the one we're talking about right now, Mr. Gotten testified that at all times the petitioner wanted to plead guilty. There's no evidence that he would have gone to trial on this charge, but for the advice but for the counsel's failure to challenge evaluation. Just generally as well, I want to clarify something that counsel said here about the exonerating affidavit, and just generally the notion that petitioner would want to proceed to trial. That exonerating affidavit turned out to be not exonerating, because Mr. Lee, before these plea negotiations, in the middle of these plea negotiations, Mr. Gotten reached out to Mr. Lee's attorney. Mr. Lee told Mr. Gotten that Mr. Lee is the co-defendant on the second charge who wrote the exonerating affidavit. Mr. Lee's attorney informed Mr. Gotten that Mr. Lee said he had signed the affidavit under duress, that if he came to trial, he would not testify according to the affidavit. He would take the fifth. It would not assist the petitioner here. So even before the pleas were finalized, the petitioner knew that Mr. Lee was not going to come to trial and testify favorably to him. I'm just going to rely on my brief for my discussion of chronic because it clearly doesn't apply as the standard prejudice standard in this case. And unless this court has any further questions, I'm just going to ask this court to affirm the denial of the petitioner's claims, and actually even before that to find that the post-conviction court should have dismissed this petition because this court has previously ruled on this exact claim.
Ms. Decker, General, before you leave on that particular issue, when we look at the record, are we going to see that the state filed a motion to dismiss this in the trial court or the post-conviction court?
The state did not file a motion to dismiss it, but in the response,
Was it argued that this
Yes,
has
it
already
was.
been decided?
yes, it was. The state in its response to the petition reserved all defenses. And then in the PC hearing itself, throughout the post-conviction hearing, there's multiple references to the motion to withdraw hearing. And in fact, as I said, the hearing transcript itself was introduced. But if you look on page 68 of the transcript for the post-conviction hearing, Ms. Beard specifically says, this goes to our argument that all of these issues have been previously litigated and ruled upon by the court. So I don't think the state has waived this claim.
Thank you.
Yes, Counselor, it's your time. Again, you got 5 minutes.
Please the court, Your Honor. Thank you. To address Judge Easter's question at the end of Appellee's argument, the state did not file a written response to this motion for post-conviction until I think well over a year after the petition had been originally filed. And certainly the court can look through the record and see the date of that. It was not until I think well past what is the statutory timeline for them to file a response. So it would be our position that any filed response, and even in that context, their filed response was very thin, I think a page long, as counsel suggested, reserving all defenses, would have been filed in an untimely fashion with respect to this post-conviction. And while they did raise it in argument, had not been something that they had moved to dismiss or raised as a grounds for dismissing the petition prior to, at least in any specificity, until we were partially through the hearing itself. So it would be our position that the state has in fact waived those claims. But I would also like to address Appellee's assertion about some, I think what they claimed were factual misrepresentations on the part of appellant in the brief and in the original argument, and submit that the court should review the entirety of the record, the original testimony of Mr. Gotten, and certainly the post-conviction testimony of Mr. Gotten to get a complete picture. I think there are probably a number of instances where a singular quote could look like Mr. Gotten had advised one way or taken one position, but when examining his entire testimony, his original position in the petition for post-conviction was that he did not remember why he had made certain decisions. He did not even recall, for example, looking at the factual disparity between what the state had pled at the amount of 10,000 versus the amount that was actually in the discovery. And in fact, I think his testimony suggested that he hadn't thoroughly looked at the discovery because he wasn't prepping for trial, so he didn't remember. So while it is true that he later then gives rationales for why he acted or did not act in a certain way, based on knowing that information, he also testified in the same hearing that he didn't remember why he didn't know that information. And that's part of the reason why appellant is making the argument that the evidence does preponderate against taking the credibility of Mr. Gotten in this case ahead of the credibility of Mr. Curry, largely because Mr. Gotten did not seem to remember many details about the case, let alone the specifics of conversations. And in fact, his testimony does change at various points through multiple directs, redirects, re-redirects, re-recrosses. The information and the justifications did change throughout that process. And it's our position that the information that we've provided as sort of the factual picture and the rationales that were given are based on a totality of all of the things that Mr. Gotten said, rather than an individual sentence here or there. And it is true that Mr. Curry did mention that he thought that he had a good chance, a real close chance, based on the advice that was given to him by Mr. Gotten. But based on the testimony that was actually given by the people involved, and based on Mr. Gotten's own claim that he did extensive research into figuring out how this particular judge would rule on an issue like this, it should have been clear, it should have been obvious, if that research really was done, that somebody in Mr. Curry's position did in fact not have a real good chance or a real close chance at getting this program. It just has not happened in anybody's memory. And the distinction between whether they know in fact it did not happen or whether they just don't recall an instance where it did happen, if all of this extensive research had been done into this particular judge's decision making, then certainly if it had happened, an instance would have arisen where they could point to saying this is an instance where somebody facing this kind of time with this kind of criminal history would have been given this opportunity. But it's our position that that research would not have borne out, that the lawyer, had they done research, had they investigated this case, would have advised Mr. Curry of the actual picture he was facing in making a decision about pleading guilty, that the odds were actually real good and real close, that he would have been sentenced exactly how he was sentenced, which was to 2 15-year terms to be served consecutively under mandatory law. And Mr. Curry, I think, has repeatedly and routinely been treated as somebody who, because he has lived his life within the criminal system, should have understood all of this. But the reality is, even if Mr. Gotten's position, which I think is what he actually testified to in a portion of the trial, was that he told Mr. Curry, you have to plead guilty to get Jericho. He meant you have to have a final judgment. So in his mind, he meant a final judgment is necessary to get Jericho, and that could also be going to trial. But in the context of getting,
ask you a question.
I'm sorry, go ahead. Yes.
In that context, counsel said that part of the reason he did not want him to go to trial was he would have to testify, and all of the circumstance of his prior felonies would come out, and that once that happened, then there was no chance he would get to go to Jericho. Now that's as I understand what his attorney said.
Yes, Your Honor. So first of all, certainly the rules of evidence 609 allows a testifying individual's criminal history to come through to attack their credibility, but 609 would not apply if he chose not to testify. And the court was already aware of those 609 convictions in the process of determining Jericho. So the court, who was ultimately the decision maker on whether he got Jericho, was certainly familiar with his criminal history. That's part of the Jericho evaluation process. And that information would have only gone to a jury if, in fact, Mr. Curry chose to testify. And, you know, our burden in evaluating whether or not he should have pled guilty is not necessarily would he have won at trial, but whether he would have decided to go to trial. And in this situation, there is no rational reason why someone who has a full picture of knowing that they could be sentenced to the exact same thing, 30 years, that there is a high likelihood that he would not get any sort of alternative sentencing, that the two charges carried mandatory consecutive sentence, would ever choose to not take the chance of going to trial. Especially, and I know Appellee, and Appellee is absolutely correct in their description of what Mr. Lee's counsel had claimed about Mr. Lee's willingness to testify. That is certainly true, but there is a lot of time between a plea of guilty and a trial. And as Mr. Gotten had himself admitted, he had done nothing to prepare for or plan for a trial. There is no way for us to know what kind of defenses could have been pursued, whether other people could have corroborated that Mr. Lee was in fact the person who had perpetrated this without Mr. Curry's involvement, that there would have been a way to get to that evidence without Mr. Lee testifying. We know that he swore under oath, regardless of the circumstances in which he did it. We know that at least he had sworn under oath at some juncture that he was the person responsible. The only question in this situation is, would he have pled guilty? And I think even Mr. Gotten has admitted that he did not want to plead guilty to these charges. He didn't want to plead guilty to the full amount in controversy of $10,000 on one of the indictments, and he did not want to plead guilty to the second indictment entirely. And whether he would have pled guilty to a lesser amount, it does not change the fact that he would not have pled guilty to these amounts, but for the fact that he had this mistaken belief that he had to plead in order to get it. And whether that's because
Thank you,
counsel
counsel.
didn't adequately.
Thank you, counsel. Your time is up.
Thank you, Your Honor.
I appreciate the arguments given by both counsel today. I think that we clearly know the issues that are before us, and thank you for your advocacy this morning. We'll take this case under advisement, and we'll stand adjourned to the call of the next case at 10 o'clock. Thank you.
Thank
Thank
you.
you, Your Honors.
This Honorable Court of Tennessee is now in recess.